Okay, so I'm back. Itaguyod na natin to. Aggravating circumstances. Aggravating circumstances, kung kanina mitigating circumstances, nababawasan yung imposable penalty. Sa aggravating circumstances naman, nadadagdagan. Ito yung plus sa plus minus na sinasabi ko kanina. Kasi 'di ba kapag may crime, yung liability mo, medium yan. Kapag divisible, yung penalty. So, kapag mitigating, nababawasan, nagiging minimum period. Kapag aggravating naman, nagiging maximum. Paano kapag may mitigating and aggravating sa isang case? Then, they offset each other. Plus minus nga. Meron iba't ibang uri ng aggravating circumstance. So, pwedeng generic aggravating, parang yung ordinary, pwedeng ma-offset. Ganun yan. Pag specific aggravating naman, ito yung specific sa isang crime. Qualifying aggravating circumstance, tinatransform niya yung isang crime. Like for example, homicide pero attended by qualifying aggravating circumstances, nagiging murder. Inherent aggravating circumstance and special aggravating circumstance. So, discuss natin isa-isa yan mamaya. So, in aggravating circumstances, the offender is punished more severely due to the greater perversity attending the crime gleaned from the status of the offender and the offended party, the relationship, the place and time where the crime is committed, and or the manner of the execution which should be alleged and proven by the prosecution. So, yung nagpo-prove ng guilt ng accused, 'di ba, si prosecution. Kung may i-allege sa information na aggravating circumstance, yung burden of proof nito is nasa kay prosecution din. So, generic aggravating circumstance, those that can generally apply to all crimes. When attendant, they increase the imposable penalty to the maximum period of that which is prescribed, except when offset by ordinary mitigating circumstances. Kasi again, 'di ba, pag privileged hindi na offset. So dapat ordinary mitigating circumstance yung mag-offset dito. So pasadahan natin. First is contempt or insult of public authority. Manonotice nyo hindi siya same order dun sa Article 14. Kasi, dito sa notes ko, kinlassify ko na siya, kinategorize ko na kung generic ba or ibang uri ng aggravating circumstance para mas madali sa atin. So, yung lahat ng sasabihin ko now is generic aggravating circumstance. Contempt or insult of public authority. Requisites, public authority is engaged in the exercise of his functions. So, important, engaged in the exercise of his functions when the crime was committed against him. Second, public authority is not the person against whom the crime is committed. So, hindi inaatake yung public authority mismo. Yung presence niya lang. At nag-e-engage si public authority sa functions niya, tapos may crime na na-commit, pero hindi against sa kanya. Alam ni offender knows him to be a public authority. Alam ni offender na may public authority dyan. Pero ultimate disrespect. Kaya siya aggravating. Alam niyang may public authority, nag-commit pa rin siya ng crime against another sa presence niya. So yung presence, yung last requisite is, the presence of such public authority has not prevented the offender from committing the criminal act. So ultimate disrespect. Next, advantage should be taken by the offender of his public position or office. Ito naman, si public officer yung offender. Okay? So, yun yung first requisite. Offender is a public officer. By the way, this circumstance is a generic aggravating circumstance, but it can also be a special aggravating circumstance. So, first, offender is a public officer. Second, such officer used the influence, prestige, or ascendancy which his office gives him. And the same was used as a means by which he realizes his purpose. Sorry kung parang hindi na ako particular sa pronouns kasi usually he naman yung ginagamit, but just don't mind it, and don't take offense if I'm not being politically correct. Not all criminals are male, 'di ba? So he or she yan, but yon. So dito, ginamit niya yung public office niya in order to facilitate the commission of a crime. So, aggravating yan. Next is abuse of confidence, another generic aggravating circumstance. The offended party had trusted the offender. The offender abused such trust by committing a crime against the offended party. And the abuse of confidence facilitated the commission of the crime. So, importante that the abuse of confidence facilitated the commission of the crime, Hindi porket like you trust the for example, the offended party trusted the offender, pero hindi naman siya related dun sa crime committed. So, kailangan ginamit yung abuse of confidence. Next is obvious ungratefulness. Requisites. Offended party had trusted the offender. Offender abused such trust by committing a crime against the offended party, and that the act was committed with obvious ungratefulness. Self-explanatory na din naman kapag sinasabi ko. So, place of commission of offense. That the crime was committed in the following places with the intention to commit such crime. So, in the palace of the chief executive or the president, sa Malacanang ka nag-commit ng crime, or in his presence. Where public authorities are engaged in the discharge of their duties. So, mga government offices. And in a place dedicated to religious worship, such as churches, ganon. Next is nighttime. Nighttime, magkakaiba to pero lumped siya sa isa. Nighttime, uninhabited place or by a band. So, yung commonality nila, syempre nighttime, gabi. Uninhabited place, diba? Uninhabited place and by a band. So, later, i-discuss ko isa-isa yan. Yung, kung ano yung uninhabited place, yung definition niya, kung ano yung band. Pero for now, papasadahan lang natin. Basta yung common dito is, yung ginamit yung nighttime and uninhabited place and by a band to facilitate the commission of the crime. And, ito yung pinaka-importanting requisite. It was especially sought by the offender to ensure the commission of the crime or for the purpose of impunity. When you say impunity, yung you can get away with it, parang ganon, without bringing harm to yourself or without making yourself parang vulnerable to getting caught, parang ganon. Next is on occasion of a calamity. That the offender took advantage of a calamity or misfortune such as but not limited to conflagration, shipwreck, earthquake, or epidemic, and committed the crime during its occasion. Next is the use of means involving great waste and ruin. So that the crime was committed by means of inundation, fire, poison, explosion, stranding of a vessel, derailment of a locomotive, and any other artifice involving great waste and ruin. So, grabe yung casualty or yung devastation na yung means na pinili mo, ang daming casualty or grabe yung degree of devastation. Next is with aid of armed men or means to ensure impunity. Requisites that the armed men or persons took part in the commission of the crime directly or indirectly, and the accused availed himself of their aid or relied upon them when the crime was committed. Next, by motor vehicles, airships, or other similar means. That the crime was committed through the use of motorized vehicles or other efficient means of transportation similar to an automobile or aircraft. That such vehicle or means of transportation was used to go to the place of the crime, carry away the effects thereof, or facilitate their escape. Nababother ako kung vehicle or vehicle to Wait lang, search nga natin. Yung proper pronunciation. Sorry. Sorry kung nagda-digress ako. Pronunciation. Vehicle. Tama, vehicle.
Vehicle.
Okay. Vehicle. Hindi vehicle. Vehicle. Okay. So, tama naman tayo doon. Okay, next. use of persons under 15 years of age. That the crime is committed with the aid of children under 15 years of age. So, aggravating siya. Next is the use of craft, fraud, or disguise. That the crime is committed by means of craft, which is the intellectual trickery and cunning on the part of the accused, fraud, insidious words or machinations used to induce the victim to act in a manner which would enable the offender to carry out his design or disguise any device to conceal identity. Okay, next is that the crime is committed in the dwelling of the offender. Requisites. An act was committed in the dwelling which may pertain to a building structure which is exclusively used for rest and comfort, and that the offended party must not have given provocation. Next is breaking of parts of the house. Requisites: breaking of the wall, roof, floor, door, or window as a means to the commission of the crime. And breaking was used as a means to effect entrance and not merely for escape. So, entrance, ingress, hindi pang egress. So, means kasi, yung aggravating dito, nagsira ka ng parte ng bahay in order to commit the crime, not to escape. So, yung aggravating dito is the ingress. Unlawful entry, that the crime is committed by using an entrance that is effected by way not intended for the purpose. This circumstance is aggravating only when the offender resorted to any means in order to enter the place for entrance or egress and not for escape, exit, or egress. So, yun. Recidivism, same lang din sa sinabi ko kanina. Recidivism, that the offender requisites that the offender is on trial for an offense that he was previously convicted by final judgment of another crime, that both the first and second offenses are embraced in the same title of the RPC, and that the offender is convicted of the second or subsequent offense. So, ano to kasi, parang may crime ka pa nga, umulit ka pa, so aggravating siya. Reiteration or habituality, that the accused is on trial for an offense, that he previously served sentence for another offense to which the law attaches an equal or greater penalty, or for two or more crimes to which it attaches lighter penalty than that for the new offense, and that he is convicted of the new offense. Next is price, reward, or promise. Yung requisites ito is, there must be two or more principals. Yung una is the one who gives or offers the price, reward, or promise, and the second one is the one who accepts it. And the price, reward, or promise must be for the purpose of inducing another to perform the felonious act. And lastly, evident premeditation, that the prosecution must prove the time when the offender determined to commit the crime, and an act manifestly indicating that the culprit has clung to his determination to commit the crime, and there is a sufficient lapse of time between the determination and execution to allow him to reflect upon the consequences of his act and to allow his conscience to overcome the resolution of his will. So, yun yung generic aggravating circumstances. So, punta naman tayo sa specific aggravating circumstances. So, these circumstances apply only to particular classes of crimes. Nevertheless, they are treated in the same manner as generic aggravating circumstances. So, pwedeng ma-offset and dadagdag ng penalty. Same effect. Ano yung mga to? Disregard of rank, age, or sex due the offended party, applicable only in crimes against persons and honor. So, specific siya kasi against person, crimes against persons and honor lang siya applicable. So, insult or disregard was made on account of rank, which is a designation or title used to fix the relative position of the offended party in reference to others. There must be a difference in the social condition of the offender and the offended party for this to be appreciated. Age may refer to old age or tender age of the victim, and sex refers to the female sex lang. And such insult or disregard was deliberately intended. Next naman is superior strength or means to weaken the defense. It's a special aggravating circumstance. Abuse of superior strength or means be employed to weaken the defense is applicable only in crimes against persons. So yung requisites, there is a notorious inequality of forces between the victim and the aggressor, and the offender purposely used excessive force out of proportion to the means of defense available to the person attacked. This is not appreciable in spur of the moment crimes unless there is clear disparity in strength. So dapat pinagplanuhan siya unless merong disparity in strength. So merong case dito, I forgot kung ano yung title ng case. Pero ano siya, I think Butler yata. Yung merong disparity in strength kasi yung victim is a girl that's 4'11", tapos the guy was an African American na 6 feet tall yata. So, yun. Treachery or alevosía. Treachery applies only in crimes against persons. That's why it's also a specific aggravating circumstance. Offender consciously adopts particular means, methods, or forms tending directly and especially to ensure the execution of the crime. And the employment of such means gave the offended party no opportunity to defend himself or to retaliate. Ignominy. The means employed or the circumstances brought about must tend to make the effects of the crime more humiliating or to put the offended party to shame. So, specific aggravating circumstance siya to coercion, murder, robbery, crimes against chastity, less serious physical injuries, and rape. And lastly, cruelty. For cruelty to exist, there must be proof showing that the accused delighted in making their victim suffer slowly and gradually, causing him unnecessary physical and moral pain in the consummation of the criminal act. So the requisites are that the injury caused was deliberately increased by causing another wrong, that the other wrong was unnecessary for the execution of the purpose of the offender. Okay. So, punta naman tayo sa qualifying aggravating circumstance. Those that change the nature of the crime and the designation of the offense and resultantly increase the penalty to a higher degree. It cannot be offset by any mitigating circumstance. So, this is the equivalent of privileged mitigating circumstances and must be proved as conclusively as the guilt of the offender because they are elements of the offense. Yon. For example, for murder, yung qualifying circumstances, aggravating circumstances, elements siya ng murder. Without these qualifying aggravating circumstances, it would just be homicide. So when there is more than one qualifying circumstance present, one of them will be appreciated as qualifying while the others will be considered as having the effect of a mere generic aggravating circumstance. So, it just takes one. Example na natin yung homicide to murder. Marami kasing qualifying aggravating circumstances yan. If the killing is attended by one of these qualifying aggravating circumstances, then it transforms homicide to murder. It just takes one. If meron pa na other attendant qualifying aggravating circumstances, then i-appreciate mo siya as ordinary. So, pwede siyang ma-offset. Isa lang yung hindi ma-offset. So, homicide to murder, treachery, taking advantage of superior strength with aid of armed men, employing means to weaken the defense, or of means or persons to ensure or afford impunity, or in consideration of a price, reward, or promise, or by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment, or assault upon a railroad, fall of an airship by means of motor vehicles, or with the use of any other means involving great waste and ruin. Ano pa? On occasion of any of the calamities enumerated kanina, okay, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other public calamity. or with evident premeditation, with cruelty, but deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. Kapag theft naman, to qualified theft, if the offender is a domestic servant, if committed with grave abuse of confidence, if the property stolen is a motor vehicle, mail matter, or large cattle, if the property stolen consists of coconuts taken from the premises of a plantation. Yes, very specific. You have to understand that the revised penal code is a very old law. If the property stolen are fish products from a fish pond or fishery, and influence of drugs. Yung influence of drugs naman, RA 9165. Inherent aggravating circumstance. Those that must necessarily accompany the commission of the crime. These are already elements of the felony and are thus no longer considered against the offender in the determination of the felony. Thus, they are not appreciated as aggravating circumstances within the contemplation of Article 14 and are treated as essential elements of the offense to which they form an integral part. Thus, they generally do not serve to increase the penalty. For example, ignominy sa rape, or breaking of a wall or unlawful entry into a house, sa robbery with force upon things, or dwelling, sa robbery with force upon things and trespass to dwelling, or by a band, pag brigandage, or abuse of public position, pag malversation of public funds, and ano pa, craft and fraud sa qualified theft as an element, preventing the meeting of Congress and similar bodies, violation of parliamentary immunity, crimes against public interest in Chapter 3 of the Revised Penal Code, crimes committed by public officers in Chapter 3 of the Revised Penal Code, execution of deeds by means of violence and intimidation, crimes against property under Chapters 5 and 6, marriage contracted against provisions of the law, and rape through fraudulent machination and estafa. So, ito, parang elements na sila ng crime. So, hindi na sila hindi na i-appreciate as aggravating circumstance. Kasi, parang inherent na siya dun sa crime eh. So, even if may existence ng ganito, hindi niya dadagdagan yung penalty kasi part na siya ng crime. Element na siya, yun yung treatment sa kanya. Parricide and rape, superior strength. Treachery sa murder by poisoning and treason. Deceit sa simple seduction. Abuse of confidence sa qualified seduction, qualified theft, estafa by conversion, or misappropriation and malversation. So, special aggravating circumstance. Those which arise under special conditions to increase the penalty of the offense and cannot be offset by mitigating circumstances. Complex crime, use of unlicensed firearm when inherent in the crime or in the commission of brigandage, use of loose firearms. So, loose firearms pertain to firearms that are unregistered, possessed without a license, illegally manufactured, stolen, obliterated, lost, altered, or with a revoked license. And to be considered as an aggravating circumstance, the use of a loose firearm is inherent in the commission of a crime punishable under the Revised Penal Code or other special laws. If the crime committed is penalized with a maximum penalty lower than that prescribed for illegal possession of firearm, the penalty for illegal possession of firearm shall instead be imposed. If the crime committed is penalized by the law with a maximum penalty equal to that imposed for illegal possession of firearms, the penalty of prisión mayor in its minimum period shall be imposed in addition to the penalty for the crime committed. It is absorbed as an element of a crime if the violation should be in furtherance of or incident to or in connection with the crime of rebellion, insurrection, or attempted coup d'etat. If the crime is committed by the person without using the loose firearm, the violation of RA 10591 shall be considered as a distinct and separate offense. It is special aggravating, yung use of loose firearms is special aggravating in murder and homicide. use of explosives. So, special aggravating circumstance din to. Hindi to ma-offset. Again, ano din to? Counterpart ng privileged mitigating. Parang sinabi ko na yan kanina, yung cannot be offset, Syempre, qualifying cannot be offset rin. Pero, itong, ganun din sa special aggravating circumstance. Pero yung reasons sila different. Ito pala talaga yung parang counterpart ng privilege mitigating circumstance, yung special aggravating circumstance. Yung qualifying kasi, nagta-transform siya Okay, continue. Use of explosives. The decree codifying the laws on illegal or unlawful possession, manufacture, dealing in, acquisition, or disposition of firearms, ammunition, or explosives provides that the use of explosives or incendiary devices in the commission of a crime resulting to the death of a person shall be considered an aggravating circumstance. It includes but is not limited to hand grenades, rifle grenades, other explosives such as pillbox, Molotov cocktail, bombs, firebombs, and other incendiary devices capable of producing destructive effects on continuous objects or causing injury or death to any person. Next is use of dangerous drugs and arson under PD 1613. It is considered special aggravating circumstance if it is committed for the benefit of another because of hatred towards owner or occupant of the burned property with intent to gain, or by a syndicate which is a group composed of 3 or more persons committing the offense. Taking advantage of public position and membership in an organized syndicated crime group, error in personae, quasi-recidivism, organized syndicate crime group as offender in crimes involving gain or profit, such as theft, estafa, robbery, and illegal recruitment. So, an organized syndicated crime group consists of 2 or more persons collaborating, confederating, or mutually helping one another for purposes of gain, for the purpose of gain, committing any crime. When a crime is committed by an organized or syndicated group and the purpose of such crime was to gain, the maximum penalty shall be imposed. Sorry, para ako nagra-rap. Okay? Nakakapagod din magbasa. Okay, punta na tayo sa parang iisa-isahin na natin. So, cases when penalty is not increased despite the presence of aggravating circumstances. Aggravating circumstances which are included by law in defining the crime and prescribing the penalty, and aggravating circumstances inherent in the crime to such degree that it must be of necessity. It must necessarily, Wait lang, ayusin natin. It must necessarily accompany the commission thereof. Aggravating circumstances are personal to the offender. So, that are personal to the offender. These circumstances shall only serve to aggravate the liability of the principals, accomplices, and accessories as to whom such circumstances apply. So, kailan? If it involves moral attributes of the offender, such as evident premeditation, or private relations of the offender with the offended party, consanguinity or affinity. So, pag may aggravating dyan, relating to private relations or relationship, then kung sino lang may relationship noon. So, for example, if it's in conspiracy, mag-a-apply lang dun sa co-conspirator na may relationship dun sa offended party. Hindi na mag-a-apply dun sa iba. Okay, example. Someone was murdered by a group of people and yung isang miyembro ng group na yon is husband ng victim, diba? So, parricide sa kanya, murder sa iba, or homicide as the case may be. Aggravating circumstances which depend on the knowledge for their application. The following circumstances shall serve to aggravate the liability of only the persons who had knowledge of them at the time of the execution of the act or their cooperation therein. So, circumstances related to the material execution of the act and circumstances related to the means employed to accomplish it. Effective failure to allege knowledge of public authority status and the information. So ito yung sa aggravating circumstance na committing a crime in the presence of public authority. Failure to expressly allege the information that the accused had knowledge that the person attacked was a person in authority or in the presence of a person in authority kung hindi yun yung ina-attack niya. Kasi 'di ba, iba yung aggravating circumstance due to rank na alam mong public authority siya, tas you committed crimes against him. Iba naman yung in the presence of, na alam mong may public authority dyan, but still you committed the crime. So, kailangan i-allege yun sa information ng prosecution if gusto nilang ma-appreciate yung ganong aggravating circumstance. So, yung insult or disregard of rank, age, and sex must be deliberately intended. There must be evidence that in the commission of the crime, the accused deliberately intended to offend or insult the sex or age of the offended party. So there must be evidence na ganon. And it is not considered when the offender acted with passion and obfuscation. There exists a relationship between the offended party and the offender, or when the condition of being a woman, kung sex, is indispensable in the commission of the crime. So, kung rape siya, for example, hindi mo na i-appreciate yung disregard of sex. Diba? At male yung offender. So, guidelines to prove age. Ito yung, with the use of children below age 15. So, aggravating yan, diba? Okay. So, the court established the guidelines in appreciating age, either as an element of the crime or a qualifying circumstance as follows. Yung best evidence is the original or certified true copy of the certificate of live birth of such party or birth certificate. In the absence of such birth certificate, then similar authentic documents. In the absence pa niyan, okay, ano ba yung mga similar? Like baptismal siguro, baptismal certificate, ganyan. In the absence pa niyan, the testimony, if clear and credible, of the victim's mother or member of the family, either by affinity or consanguinity, who is qualified to testify on matters respecting pedigree, such as the exact age or date of birth of the offended party, pursuant to Section 40, Rule 130 of the Rules on Evidence, shall be sufficient in the following circumstances. So, if the victim is alleged to be below 3 years of age, what is sought to be proved is that she is less than 7 years old. Kailangan ko ba itong basahin? If the victim is alleged to be below 7 years of age, and what is sought to be proved is that she is less than 12 years old. If the victim is alleged to be below 12 years of age, and what is sought to be proved is that she is less than 18 years old. In the absence of the foregoing, the complainant's testimony will suffice, provided that it is expressly and clearly admitted by the accused. It is the prosecution that has the burden of proving the age of the offended party. The failure of the accused to object to the testimonial evidence regarding age shall not be taken against him. So, punta naman tayo sa dwelling. Dwelling, again, sinabi ko na kanina, building or structure exclusively used for rest and comfort. Pwede naman na tindahan din siya. Kasi may case na ganun tindahan. Pero tindahan siya at the same time, yun din yung bahay niya. So, hindi ibig sabihin nito na it's just for rest. What it means is that, dyan ka nga namamahinga or ginagamit mo nga siya for pahinga talaga. A lessee, boarder, or bed spacer can consider such place as his home, the sanctity of which the law seeks to uphold. Basta yung kailangan lang dito intindihin is, dyan ba siya talaga natutulog? Hindi yung parang nasa office ka tapos natulog ka lang doon. Hindi ganun. So, dwelling. Dwelling includes dependencies such as the foot of the staircase and enclosure of the house. So, bakit may ganito? Kasi maraming cases yan Kahit nasa ka pa lang, papasok ka pa lang, hindi ka pa talagang nasa gitna ng bahay. Basta nasa nasa enclosure ka na ng bahay. Dwelling na yon, so aggravating na yon. Dwelling cannot be appreciated as an aggravating circumstance when the rape is committed on the ground floor of a 2-story structure, the lower floor being used as a video rental store and not as a private place of abode or residence. So, pwedeng same building siya, 'di ba? Pero, kunwari, yung taas, yun yung ginagamit for rest and comfort, exclusively for rest and comfort. Yung baba, yun nga, video rental store. Kung nirape siya dun sa taas, aggravating yung dwelling. Kung nirape siya sa baba, hindi aggravating yung dwelling. Dwelling should not be understood in the concept of a domicile. A person can have more than one dwelling. So, for example, meron kang condo, tapos meron kang bahay talaga ninyo. Yun yung permanent address mo. So, pag may ginawa sa condo, 'di ba? Pwedeng aggravating yung dwelling kahit na meron siyang permanent address somewhere else. It is considered as an aggravating circumstance even without entry to dwelling. It is enough that the victim was attacked inside his own house. Dwelling is still aggravating if the commission of the crime began inside the dwelling. So, merong case nito. Pinasok yung bahay, nag-start yung bahay, tapos they dragged the victims outside of the house and then they shot them outside of the house. So, in this case, dwelling is still aggravating because it started sa dwelling, even if they finished him off outside of the house. When both offender and offended party are occupants of the same house, even if the offender is a servant or kasambahay, it is not considered aggravating. So, hindi siya applicable between housemates. It is neither appreciated as aggravating when the owner of the dwelling gave sufficient and immediate provocation. And dwelling is not aggravating because it is inherent in the crimes of trespass to dwelling and robbery with force upon things. If dwelling and unlawful entry are both present in the case, they're taken separately. Hindi sila kino-combine kasi magkaiba eh. Dwelling, sa bahay mo ginamit na used exclusively for rest and comfort. Kasi yan yung place na yung tao binaba niya ng defense niya kasi safe space niya yan. 'Di ba? Yung unlawful entry naman, iba yung niya, elements, 'di ba? Pumasok ka sa hindi dapat pang-ingress. So, unlawful, na wala kang authority. So, magkaiba sila. When an officer, after giving notice of his purpose and authority, is refused admittance to make an arrest when breaking of parts of the house is lawful. When an officer, after giving notice of his purpose and authority, is refused admittance to make an arrest in any building or enclosure where the person to be arrested is or is reasonably believed to be, to effect search in the place of directed search, and to liberate himself or any person lawfully aiding him when unlawfully detained in the place of directed search. So, ito yung times na parang, lawful. So, walang criminal liability sa cases na to. Abuse of confidence naman tayo. Confidence between the offender and the offended party must be immediate and personal. If two persons just met for the first time, there can be no personal or immediate relationship upon which confidence might rest between them. So again, inherent to and hindi aggravating sa qualified seduction, qualified theft, estafa by conversion or misappropriation, and malversation. So punta naman tayo sa nighttime or nocturnidad. Madami pa ba to? Pagod na ako. Konti na lang. Okay. So, nighttime or nocturnidad. The commission of the crime must begin and be accomplished in the nighttime, after sunset, and before sunrise. It is aggravating if the darkness facilitated the commission of the offense and the darkness was... Ito yung importante. Hindi lang facilitated. Dapat, ang daming cases na to purposely sought by the offender to ensure the execution of the crime. So, hindi porket gabi, aggravating na yung nighttime. Kahit na nag-facilitate pa yan. Dapat, pinlano talaga ni offender na, okay, gagamitin ko yung, I will take advantage of the night. Ganun dapat. Pero kung, hindi naman nag-facilitate, 'di ba? Kahit nighttime ginawa yung crime, nagkataon lang, or wala naman pake kung nighttime or daytime, or sure nakatulong siya, pero hindi naman talagang inisip ni offender through his actions, kailangan overt actions, diba? Through his actions na talagang pinlano nila na sige, hintayin natin maggabi. Kapag wala namang ganun, hindi pwedeng i-appreciate yung nocturnidad. uninhabited place, it is determined not by the distance of the nearest house to the scene of the crime, but whether or not in the place of the commission of the offense there was a reasonable possibility of the victim receiving some help. So, hindi siya yung mathematical computation na uninhabited siya kasi ang layo ng kasunod na bahay, or hindi siya uninhabited place kasi may malapit naman na bahay. Hindi ganon. Reasonable, diba? Based sa circumstances na pag sumigaw ba siya dyan, may makakarinig sa kanya. Kung wala, uninhabited place siya. And solitude must be sought to better attain the criminal purpose. Again, kailangan pinlano din talaga, hindi nagkataon lang. When the place of crime could be seen and the voice of the victim could be heard from a nearby house, the place of the crime is not uninhabited. Band or quadrilla. It is necessary that there be more than 3, meaning at least 4, armed malefactors, kailangan armed, acting together in the commission of the offense. This aggravating circumstance requires that there should be at least 4 persons who commit the crime, all of whom should be armed. Even if there are 4 offenders but only 3 or less are armed, it is not a band. Hindi siya i-appreciate as aggravating. If only 2 of the accused carried firearms, again, hindi ma-appreciate. Abuse of superior strength and use of firearms are absorbed by the aggravating circumstance of by a band, if merong by a band. So, pag by a band na siya, hindi mo na idadagdag yung abuse of superior strength. Kasi similar lang din naman sila. Pwede mo sabihin abuse of superior strength kasi 4 sila. Hindi. And hindi rin yung use of firearms kasi yung definition nga ng band is armed sila. So, malamang. Hindi pwede doble-doble. Brigandage is committed by more than 3 armed persons forming a band of robbers, making the circumstance of by a band inherent. Meaning, dahil inherent sa brigandage, hindi siya appreciate as aggravating circumstance. So again, pag inherent, hindi mo na siya i-appreciate as separate aggravating circumstance. Armed men, of course persons, men or women, kahit yung term armed men, equipped with weapons. Their aid is not aggravating when both the attacking party and the attacked or the offended party are equally armed. So, magiging aggravating na siya pag walang armas yung isa, tas yung isa meron. It is not applicable when the accused cooperated with the armed man under the same plan and purpose kasi pwedeng maging by a band. It is not considered as aggravating when the offender did not avail or solicit their assistance in the commission of the crime. So, kung nasaktuhan lang, diba, at nakisawsaw lang sila dyan, hindi pwede. Dapat, para ma-appreciate as aggravating circumstance, nagsabi talaga sa offender na nag-recruit talaga siya ng armed man para ma-ensure na makommit niya yung crime effectively. Use of fire with intent to kill, the crime is murder and fire is considered as a qualifying circumstance. So, kung homicide siya, magiging murder. So, kahit na, hindi siya magiging arson kahit na burn yung house in the process kung yung intention niya is patayin. Yung fire, kailangan mo i-distinguish if ano yung purpose, ano yung intention. So, murder siya kapag yung fire ginawang means to kill someone. Arson naman siya if yung fire was used to destroy the property. Ganun lang yan. So, use of fire naman to destroy property, the crime is arson, even if someone dies as a consequence during its commission. So, essence of premeditation naman tayo sa evident premeditation. Parang ang dami pa. The premeditation must be evident in that there are external acts that indicate deliberate planning. The essence of such premeditation is an opportunity for the offender to ponder with a calm mind the meaning and consequences of his plan to commit the crime. There must be an interval long enough for his conscience and better judgment to overcome his evil desire and scheme. So again, case-to-case basis kung ano yung sufficient time, kung ano yung time long enough. So, the date and time when the offender determined to commit the crime is essential. Kasi, kailangan mag-compute kung sufficient na ba. Pero, case-to-case basis, walang sinasabi si court na, okay, evident premeditation na yan if naglapse na ng 1 hour, or kailangan 1 week, or kailangan 1 day, walang ganon. Conspiracy does not presuppose premeditation except when the conspiracy is merely implied. Evident premeditation is not aggravating if there are feelings of anger or grudge on the part of the offender. Kasi magiging parang passion or obfuscation na yan. Evident premeditation is inherent and therefore cannot be aggravating in preconceived acts wherein the accused would execute the act only after having thought out the method by which he intends to accomplish it, such as but not limited to treason, arson, theft, or estafa. There is no evident premeditation and error in personae and aberratio ictus. Malamang. Kasi hindi mo naman inintend. Kahit pinlano mo yung crime, pero may mistake in blow naman, or may mistake dun sa person, yung person mo na inintend si A, yung natamaan si B, di ba? Yung evident premeditation mo nandun kay A eh. With respect to B, wala na yung homicide lang, wala nang evident premeditation doon kasi yung pinlano mo dun sa isa. So hindi mo possibly na pinagplanuhan na patayin si B. So disguise naman. If disguise was ineffective, if disguise was employed but the offender was still recognized, it cannot be considered as aggravating. So, kapag effective lang, saka lang siya magiging aggravating. Pag palpak naman, edi hindi niya na-serve yung purpose niya, so bakit siya magiging aggravating? Kasi hindi naman siya nakadagdag sa perversity ng crime. Craft and fraud absorbed in treachery. Craft and fraud may be absorbed in treachery if they have been deliberately adopted as the means, method, or form for the treacherous strategy. Otherwise, they may coexist independently where they are adopted for a different purpose in the commission of the crime. So, superior strength versus treachery. The means used must not totally eliminate possible defense of the victim. Otherwise, it will fall under treachery. When there is treachery, superior strength is absorbed. So, ano po yung ina-absorb ni treachery? Abuse of superior strength, aid of armed men, band, craft, nighttime, employing means to weaken the defense, and disregard of sex. Essence of treachery. The essence of treachery is that by virtue of the means, method, or form employed by the offender the party was not able to put up any defense. When aggression is continuous, treachery must be present in the beginning of the assault. When the aggression is not continuous and that there was an interruption, it is sufficient that treachery was present at the moment that the fatal blow was given. Treachery cannot be presumed. The suddenness of the attack does not of itself suffice to support a finding of alevosía, so long as a decision was made all of a sudden and the victim's helpless position was accidental. When there is conspiracy in the commission of a crime, treachery can be appreciated against all conspirators. So the treacherous character of the means employed in the aggression does not depend upon the result thereof, but upon the means itself. Thus, frustrated murder could be aggravated by treachery. Sudden attack. The mode of attack must be consciously adopted. The accused must make some preparation to kill the deceased in such a manner as to ensure the execution of the crime or to make it impossible or hard for the person attacked to defend himself or retaliate. Treachery may still be appreciated even when the victim was forewarned of danger to his person. What is decisive is that in the execution of the attack, it was impossible for the victim to defend himself or to retaliate. So, pwedeng alam ni victim, may nag-tip sa kanya na hala, papatayin ka na ganito. Pero, may treachery pa rin pag nagulat siya nung time na inattack na siya. A sudden attack by the assailant, whether frontally or from behind, is treachery if he deliberately adopted such mode of attack with the purpose of depriving the victim of a chance to either fight or retreat. There is treachery when the victim is shot, albeit frontally, with his hands raised to show that he would not fight, or because of fright, or to try to ward off the shots that were to come. So, bakit may treachery kasi, kahit alam niya, okay, kahit nag-hands up na siya, ganyan, kahit harap-harapan na, treachery pa rin kasi hindi niya napaghandaan yung moment na yun eh. Outraging the corpse. So, ito na yung last, finally. I think I'll have to make the alternative circumstances in a separate video because I'm feeling so tired na. Okay. Kailangan ko ng rest. It is a form of ignominy. If the victim was already dead when the acts of mutilation were being performed, this would qualify the killing to murder due to outraging of his corpse. In cruelty, the suffering is physical and must be done while the victim is alive. In ignominy, the suffering shocks the moral conscience of man and pertains to moral order, whether or not the victim is dead or alive. So, tinatamad lang ako mag-cases kasi 15 minutes na akong dumadada. Okay. So, madali lang naman to eh. Basta gets natin yung principles. Anong case yung i-discuss natin? Saan? Basta treachery, madali lang to. Medyo confusing at times, pero yun, basta dwelling. Na-discuss na natin yung dwelling. Okay, division, yan. Okay, ito, essential doctrine to. Kapag special complex, like, yung tanong dito is whether or not treachery in a crime of robbery with homicide should be treated as a qualified aggravating circumstance. No. Kasi treachery is a generic aggravating circumstance to robbery with homicide. Although said crime is classified as a crime against property and a single indivisible crime, treachery is not qualifying because homicide is used in its broadest and most generic sense. Treachery is not an element of robbery with homicide. Neither does it constitute crime specially punishable by law, nor is it included by law in defining the crime of robbery with homicide and prescribing the penalty therefore. Treachery is likewise not inherent in the crime of robbery with homicide, hence treachery should be considered as generic aggravating circumstance in robbery with homicide for the imposition of the proper penalty for the crime. So yung kaso kasi dito is robbery with homicide. Diba yung homicide, if attended by treachery, homicide alone na, if attended by treachery, nagiging murder kasi qualifying aggravating circumstance yung treachery sa murder. Sa robbery with homicide naman, robbery yung main thing dito eh. Diba? Kaya nga robbery with homicide siya eh. Yung intention talaga is intent to gain. Tapos yun, may namatay lang in the process. So, hindi siya qualifying. Hindi siya magiging robbery with murder. Diba? I-appreciate lang siya as a generic aggravating circumstance kung may treachery. Ito, importante din yung People versus Sultan. When robbery is accompanied by rape, okay, it is complexed into special complex crime of robbery with rape. Rape cannot be considered as aggravating circumstance. If maraming counts ng rape, such as in this case, diba, the additional rape will not be considered as aggravating kasi there's no law that says so. So dito kasi parang may 2 counts of of rape. Yung nangyari dito, okay, kwento ko na nga lang, story time. Sige. Kahit na tinatamad ako, itatry ko yung best ko. Okay. So, nireset ko din kasi tong case na to kaya medyo naalala ko pa. Bale si girl, galing sa pinsan niya. Okay. Uuwi na siya sa bahay nila. Dumaan siya sa parang small alley. Tapos dun sa alley na yon, it's dark, ganyan, biglang may tumutok sa kanya. Hold up daw. Pero instead na normal hold up, yung ginawa sa kanya, dinala siya doon sa isang bahay. Yung bahay pala na yon, bahay ni hold upper. So, yon, meron siyang ice pick. Sabi niya, okay, bigay mo sa akin yung mga gamit mo. So, si girl naman, binigay yung relon niya, binigay yung mga alahas niya, yung mga kagamitan niya, binigay niya kasi hold up nga. Tapos, biglang inutusan ni boy si girl na, okay, hubad, ganyan. So, nangyayari is, nirape niya. Tapos, mautak din naman tong si girl. Kinaibigan niya siguro. So, rape, ganyan. Tong si guy na in love kay girl. Yung offender. Tapos, nangyari na yung rape. Si guy, nag-pause. Nag-break time siya, mga 15 minutes. Nag-yosi-yosi muna siya sa kabilang room, ganyan. Tapos, binalikan na naman niya si girl, nakatali si girl. Nirape na naman niya. Diba? 2 counts of rape yon. Okay. Tapos, usap-usap sila hanggang sa na-inlove na talaga si boy. Tapos, gusto niyang itanan si girl. Tapos si girl naman nakiride kasi syempre ayaw niyang mamatay, diba? Sabi ni girl, sige, magtanan tayo, pero pwede bang uwi muna ako sa bahay kasi kunin ko lang gamit ko. Tapos si boy naman, pumayag. Okay, ang galing ni ate girl. So, nakaalis na dun si girl. Pag alis ni girl dun, nagsumbong siya, malamang. Tapos, meron silang parang friend, yung family friend na police. Tapos, nagkaroon ng parang entrapment operation, ganyan. Pero, hindi ko na kayo sa details. Basically, yung question is, paano yan? 2 rape. Robbery with rape, sure. Pero may additional rape, anong gagawin natin dyan? So, yun yung isang problema ng court. So, sabi sa decision, wala. Diba? Hindi mo pwedeng consider na aggravating yan kasi wala yan sa aggravating Walang rape dun sa aggravating circumstances Kahit anong hanap mo dyan, walang rape dun. Diba? Hindi rin pwedeng 2 counts kasi robbery yung main crime. Tapos rape was just, incidental. Or probably an afterthought, diba? Nagandahan siya dun sa supposed na hinoldapan niya or something. So, basta yun, kahit madami pang counts of rape yan, pag robbery with rape lang. Okay, I think I'll make a separate video sa alternative circumstances. I'll just rest. Okay, see you later.